Good evening and welcome to another Albion crime team webinar. And today's subject is the new sentencing guidelines for drug offences. I'm Ed Hetherington and to my right is Kannan Siva. And we're both members of the crime team here at Albion and both practice extensively in areas including cases involving the supply and trafficking of controlled drugs. The purpose of this session is to look at the new guidelines which come into force for cases sentenced on or after the 1st of April this year. Obviously, there are no examples of decided cases involving the guidelines, but what we hope to do is to look at the new concepts and the new language that are throughout the new guideline, and also to look at some recent decided cases that seem to point to trends within the drug trafficking industry and within the way in which drugs are produced and sold, and which might point to some trends that are going to continue in the way the new guidelines are implemented. So it's worth saying that the new guideline covers both offences under the Misuse of Drugs Act and the Psychoactive Substances Act. The most serious offences remain those under the Misuse of Drugs Act, but the Psychoactive Substances Act contains a similar structure of offences involving importation, trafficking, production and supply, and the headline maximum sentences for drugs offences don't change, remaining statutory maximum of life for the most serious offences involving Class A drugs and 14 years for Class B drugs. The sentences are generally lower for psychoactive substance offences, but with a range that allows the courts to reflect the realities of what's gone on. And the main difference in those sentencing is the concept of harm. Unlike offences under the Misuse of Drugs Act, in the Psychoactive Substances Act, when you're looking at quantifying harm, the effect of the drugs is as important as the size of the operation. And those guidelines provide an approach that sentences can use to be more flexible, perhaps. And it's a theme of these guidelines, I think, Kannan, that a little bit more judicial discretion is introduced.
Yes, what Ed and I have realised, or we predict, is that judges are going to be allowed to be more flexible. And the people who are at the bottom of the pile being used and exploited are going to get lower sentences, and those who are using them are going to get slightly higher sentences. The indications are all there. In fairness, in authorities that came out or have been coming out in 2020 and 2021, but there's an authority called Griffiths, which we'll talk about later, which talks about these drugs guidelines not having hard edges. So we feel that these hard edges are going to be removed and more flexibility, softer movement between categories, and people who think, oh, well, could be significant role or actually on the cusp of lesser role and so on. But there are some headline words, buzzwords in these new guidelines in relation to role in particular, which means that we can start thinking about how we analyse these cases and getting the material ready to show that somebody may have a limited advantage and has been schooled or groomed into the offence, even if on the face of it they look like a low-level Class A drug dealer, where a judge would have said, well, it's classic significant role category 3, isn't it? So there's going to be a change in attitude, but also acknowledging that those who deal in more potent substances and greater harm are, quite frankly, going to get hurt a bit more in terms of sentencing, aren't they?
Yes, there's no getting away from the fact that county lines as a method and a mode of drugs trafficking has had to be reflected, because it is now the single most common style of drug trafficking that comes before the courts. And so those people who are what we would normally call cuckooed or otherwise exploited, groomed by more sophisticated and more hardened criminals, have an opportunity to move from what was previously quite a rigid and a tough regime, which made it difficult for them to avoid often immediate sentences of significant custody, there'll now be more opportunity for other disposals to be available to them. The flip side of that is that where a judge forms the view that someone involved in trafficking drugs has been the exploiter, they can expect the consequent other side of the picture and a significantly harsher sentence than they might have hoped to escape with previously. The other feature of the drug market, which is now marked as well, is that there are different forms of drugs and different strengths of drugs available. So the guidelines now reflect, for example, MDMA as a powder-based drug and with indicative quantities for powder rather than simply ecstasy tablets, reflecting the change in the market there. There are also increased suspected yields. So cannabis plants move from a 40-gram yield per crop per plant upwards, and ecstasy, numbers of pills required to cross various thresholds have been reduced, as we'll come to. Both those changes and the changes to reflect spice and the use of synthetic drugs, which have been specifically criminalised in the Misuse of Drugs Act rather than falling under the Psychoactive Substances Act, are the ways in which the council have changed the guidelines and redrafted things in order to reflect the reality on the streets, rather than academic drug supply. And another practical difference that we're going to be able to latch onto is the key buzzword of disparate outcomes. Kannan.
Disparate outcomes, yes. It's now in bold type that people from certain communities, for example, BAME communities, seem to receive harsher sentences on average for same offence. And if that's being underlined to the court in the sentencing guidelines, if you've got any evidence which may give a defendant from a disadvantaged background a fighting chance of rehabilitation, get your evidence together, because the courts may stretch out a helping hand and pick them up when it comes to the difference between an immediate custodial sentence and a suspended sentence. So there are a few subjects there. What are the big changes in terms of harm and culpability for drugs guidelines, the new psychedelic substances, and trying to prevent disparate outcomes and the equality at sentencing? Now, Ed, if I can be the questioner, because we've had a chat, tell us about the big headlines on drugs quantities and how they affect the category of harm you're going to be in. Quantity.
Well, the new guidelines specifically follow the same pattern as before. So when you're looking at harm, it's quantity based. When you're looking at category 1, top end conspiracies or day-to-day drug dealing, the drugs like heroin, cocaine, LSD, amphetamines, cannabis, the quantities stay the same. The effect for cannabis that you're going to see in terms of changing how cases result is the proposed or suspected yield from which the court will work. So when you have a production of cannabis and a number of plants, the traditional formula is 40 grams per plant per crop, and then we'll work that out and extrapolate that out through the number of suspected crops you've had and the size and the duration of the operation. But the council has changed that now so that it says you can expect 55 grams. Now, of course, it's a matter of simple maths that the smaller the operation, the less impact that's going to have. But once you get up to a substantial number of plants, suddenly you're crossing thresholds much more rapidly than you previously would have done. So cannabis, the change there is the yield. With MDMA, you now have kilogram and gram thresholds to be crossed, rather than trying to work out what MDMA equates to. Do you try and make it a number of tablets, or do you try and compare it to a different powdered drug? And then ecstasy. And the Sentencing Guidelines Council have come to the conclusion, I think through academic research rather than market testing, that ecstasy is stronger now than it was in 2012 when the last guideline was passed. We've all, I'm sure, noticed that. And so now to get into the top category, rather than having 10,000 tablets, you're going to be liable to be a category 1 offence at 7,000. To get into category 2, instead of needing 2,000 tablets, that's almost halved down to 1,300. And then when you're looking at category 3 and category 4, where the differences in sentences are stark, suddenly 200 tablets rather than 300 will get you into category 3. And category 4, the indicative amount, is now just 13 tablets.
And what was it before it?
It was 20. So whereas before, if you had 25 tablets, say, you were only just a fraction, a quarter over the indicative amount for category 4, suddenly you're going to be double.
Now these figures, these guidelines are going to be reviewed regularly, aren't they? Every few years.
There's going to be a three-year review.
And if that's right, well, we've noticed trends in cocaine, for example, being higher purity on the street. And it's not out of the question, is it, that those indicative quantities we've got for 150 grams in category 3 and 1 kilogram for category 2 may well be reviewed if they take the same potency approach. So, for example, if they say, look, there's rocket fuel on the streets, those categories could also come down, could they, potentially? Or ranges change?
Ranges could change. What you might well see, of course, in the past, before the 2012 guidelines, the system was relying on extrapolating out to what would this be if it were pure.
Yeah, well, that was pre-2012.
Pre-2012.
What would it be if it was 100% cocaine, for example?
We moved then to a simple weight-based, but I think drug judges already struggle with the fact that how do you treat someone who's got a cannabis at 5, 10, 15%,
yeah,
pub grub as it might be called, really poor quality stuff, and treat them the same as someone who's got 60%, and it's just an aggravating feature that the purity is different, and that's quite a clumsy tool.
It is, and really, if you've got somebody dishing out or dealing fentanyl, which is extremely potent and far more addictive than most opiates, isn't it? I think I can't remember the potency of it, but it's recognised as a high potency opiate. This is the Prince drug, isn't it?
It is. It's
the Prince overdose drug.
Something like 80 to 100% in terms of.
And so, if you've got a small amount of that, you may find yourself in a fairly serious position if you're dealing it and supplying it to other people, because it's about harm, isn't it? The amount of harm that you can cause. And so those assessments of harm are going to be a significant feature of cases from now on, and going to require a slightly nuanced approach and a change from where we were before. The other significant change that's going to be a very common issue, I think, is the blurring or the changing of the lines in terms of roles. Definitely. Well, if I may, as long as I don't do anything too drastic, should we just have a quick look at the new guidelines on roles? I don't know if it's coming up. And there are some new words there, aren't there? It's certainly in terms of grading what an advantage you've got. So significant role is expectation of significant financial or other advantage, save where advantage is limited to meeting the offenders. And so the drug addict who's just simply selling a bit of drugs, or has been for a few couple of months even, to feed his own habit. Previously, they probably would have sneaked into a significant role, but you can see there, the bottom featuring lesser role, expectation of limited, if any, financial or other advantage, including meeting the offender's own habit. Now that last phrase, meeting the offender's own habit, has already been foreshadowed in a case called White in the CPS, which was decided in earlier this year in February 2021, EWCA Crim 141. And it was a woman who was a hopeless drug addict, and she was selling drugs under direction of somebody else, under some coercion as well, in fairness. But the Court of Appeal observed the repetition of the conduct is part of the pattern of the dealer who regularly sells from their own address at the direction of another, who avoids direct personal involvement. The advantage of a personal supply of drugs was also at the lowest level. Now that stuff would have gone into category 3 significant role before, wouldn't it? Well, where the old guidelines talked about motivated by financial or any other advantage, yeah, then plainly
that was carte blanche for judges to place any offender who was receiving anything in return for their efforts straight into significant role.
But it doesn't, sorry to cut across, but it doesn't end there, does it? Because if you look at the bottom class, the expectation of limited, if any, financial. So it's not just a situation in White and CPS, which is pre-guidelines, pausing there. If you've got a case in the next 2 weeks before the 1st of April, the case of White and CPS is perhaps helpful authority for showing that essentially the spirit of the guidelines apply. So if you are at the bottom of the chain, selling for your own habit, you should be placed in a lesser role category. And that sentence actually was half price, 3 years down to 18 months from memory, with a rehabilitative license package. So, but here it goes further on lesser role, doesn't it, Ed?
Yes, so lesser role talks about limited, if any, financial or other advantage, including meeting the offender's own habits. So you will have cases where the offender is not dealing to meet their own habit, is having a financial advantage, and you're going to be having the argument, is this limited? Of course, that's not defined. So the circumstances are going to be relevant, both in terms of the personal circumstances of the offender and how a sum of money may or may not be significant to them, and also within the scope of the operation that you're dealing with. But it is a significant opportunity for judges who were previously railroaded into looking at a significant role to have that opportunity to look at lesser role. The other aspect of lesser role, of course, or two other aspects, there's reference in why they engaged to engage by pressure, coercion, intimidation, but also now the words grooming or control, which weren't previously present. Now, grooming or control obviously have that element of taking younger, more vulnerable, addicted people off the streets and exploiting them, using them to commit offences. And what's interesting there is it is engaged by. So not involved only due to, but engaged by, meaning you've got to look at how that person first became involved in the offending behaviour. And it may well be that this is what Kannan was suggesting earlier on when he talked about the person who previously you would have looked at and said, hardened drug dealer, albeit at a low level, category 3 significant role. But if you can go back to how they became involved and show that that has a degree of grooming or control, then that is how they became engaged, and that does seem, therefore, at the very least, to engage that potential lesser role criteria.
Ed and I talked about this, and there's a case that we both had some involvement in, about what do you do with a 23-year-old who was essentially smashed into drug dealing or expedited his progress, went from foot soldier to lieutenant within the period of 2 or 3 years, because it often happens, it's a typical pattern. But if you catch them at a stage where they are taking their next steps into a higher role, such as upper significant, but you can amass evidence which shows that essentially they were engaged by grooming or control or some element of being susceptible to being put out on the streets at 14, 15. Now, they are unlikely. This is not a talk about modern slavery, but we can't get away from the fact that post-2015, Post-Modern Slavery Act and the requirement in certain circumstances to consider whether a victim or an offender, suspected offender, has been trafficked, they have an effect on these guidelines. Because if you look at lesser role again, it's not just engaged by grooming and or control, involvement through naivety, immaturity or exploitation. So we have, again, there's a word, immaturity. Previously, of course, we did have pressure and coercion and I believe exploitation, but it's underlined. The word grooming is new. So it's an acknowledgement, it's a heads up to a new way of thinking. 2 cases potentially which highlight that. Pre-guidelines, so we'll have to see how they're applied. Case called Shaka Griffiths, which came out earlier this year. Some of you may be familiar with it for various reasons, but it's 2021 EWCA Crim 130. And what happened was a defendant who had got previous convictions for drugs offences. He used the home of a heroin addict, a woman, again, who was an addict, who was right at the bottom of the chain, similar to the appellant in white and CPS. But it was the appellant Griffiths. He said, look, come on, 7 years is too high. I got a Goodyear indication of 7 years and 3 months. This is a small amount of Class A drugs, and it's admittedly it's over a few months, but why are you whacking me for? Now, the reason it may be that Mr. Griffiths was unfortunate in the Court of Appeal is that although they didn't explicitly say this, at least obiter, the principle, is perhaps hinted at in paragraph 7. In sentencing, the judge found that the appellant had established his base of operations at Miss Doran's house. She dealt the drugs under his direction and control, the stock being brought by him from Bristol. This process had been going on for about 3 months. Headline, if you're using somebody who has been groomed or controlled, your position, I'm afraid, is probably going to slip up the category at the very least. So if you're significant role category 3, that offender may well be right at the top of the range. And it was Griffiths, the Court of Appeal in Griffiths, that said that these aren't hard edges, these categories and roles. So there may well be more movement, which is probably what the judges want to do anyway, which is not be bound very tightly if they see some vulnerable drug addict trying to make the best of their lives and move on, and having somebody who's exploited in their eyes may seem to ruin their life. So people are going to have to expect more, and maybe harder to advise defendants, actually. What do you think, Ed?
I think that's right. I think this is that theme that we talked about of judicial discretion seeping back in. You're still sharing the
oh, sorry,
the guidelines there.
The guidelines.
People could be looking at us.
Well, they could be looking at us, and I don't want to stop that. The guidelines.
The thing that we talked about before of judicial discretion seeping back in, and those rigid guidelines really taking away the opportunity for judges to exercise all of those years of experience of how drugs and drugs exploitation actually works, maybe reversed a little bit. And there are those Court of Appeal authorities that you referred to that show that's a trend already. These guidelines seem to provide for that to be more explicitly done, and also done in a way that avoids what's been described by the Court of Appeal, I think in the case of Cornett, a 2020 case, as bunching.
Yeah, bunching. Bunching is, again, described in a case called Cornett, where putting it bluntly, some big fish tried to reduce some big sentences, if I can put it that way. So then, certainly Mr. Powell, Queen's Counsel, didn't dispute that his client had a leading role with a large quantity of drugs. But what is bunching? The Court of Appeal described it as the sentences of those at the very highest end of the hierarchy should not be unjustly too high, just so that there can be a sufficient gap between them and those lower down. Now, with words like grooming and control, which clearly reflect understanding of people who have been at least partially drifting into some kind of quasi-forced labour. They may not have a defence under the Modern Slavery Act, but they may be at least partial victims of being sucked into drug dealing. Now, those people who are at the top of the tree, who set up the machinery, my prediction is that there could be bunching with those, or a degree of bunching with those at the highest end of the hierarchy receiving aggravated sentences. For example, in Cornett, it acknowledged county lines as a problem. Appellant counsel for defendant appellant 1 said, look, you can't just aggravate it because it's county lines. And they said, no, it is an aggravating feature because of the inherent mischief of these people being sucked into these operations. Those aren't the words of the Court of Appeal, but you get my point, Ed.
I do. And so if we consider this now more dynamic drugs market and this realization that 3 categories can be a slightly simplistic way of looking at drug sentencing, as a practical measure, increasingly, both in defending trials, but also in preparing mitigation, there's an increased tendency to consider instructing experts?
Yes. Now, I've recently had the benefit of working with a very able expert who is possibly a delegate tonight. And what the expert was able to do is that despite the Crown's indifference to the defendant's very low position in the pecking order, essentially somebody who was cuckoo, yes, they know that, but where does that person fit into the overall hierarchy? And that's where experts in county lines and other issues relating to forced labour may be of assistance if the evidence is silent on the topic. I'm not advocating that it's just routinely dished out or instructed, or the taxpayers' money is wasted if you're representing some of the people we've talked about, El Chapo and others. But if you've got somebody who is vulnerable or potentially vulnerable, and there is evidence of control, grooming, level of exploitation, where an expert in the structure of county lines may be able to assist, particularly in larger cases such as conspiracies, it might have a significant effect on informing a judge to make the right decision, saying, well, hang on, it's not just lesser role, it's ticking a lot of boxes there on those lesser role categories, like grooming and control and immaturity and the way that the person was engaged. So there is I believe there will be a need at times in the right cases for expert evidence to assist the tribunal. And yeah, so it's a dynamic market, isn't it? It's a dynamic set of guidelines.
It is. Just thinking about it from a practical point of view.
Yeah.
If you have the kind of case where you're raising those issues, it might very well be the kind of case where you agitate for, if it hasn't already been done at the police stage, a referral to the NRM, the National Referral Mechanism on Human Trafficking and Exploitation. But if the indications are that either the Crown are going to progress the case towards a trial and wait and see what the answer is, or that notwithstanding the outcome of that, they still intend to prosecute the matter, you may simultaneously need to think in preparing the case about instructing an expert of this sort. And of course, they'll then be linked to the materials disclosed out of the NRM to feed any report, or maybe an addendum report. But instructing an expert relatively early when the NRM's in force is often going to be a good idea.
It may well be, it could well be a good idea, especially if you've got those legitimate concerns, because my view is that by expanding the lesser role category to make it more inclusive for those people who are being exploited, it's essentially telling a court or inviting a court, you're going to have to attach far greater weight to this mitigation than you did previously. And it may well be a matter of a sentence, rather than simply saying, well, you can't prosecute our guy because he's a victim of modern slavery. You can't prosecute our guy because, again, I don't say that disparagingly. It really means there are certain cases which, of course, require immunity from prosecution, or would welcome immunity from prosecution. But most cases, bluntly, fall into that hinterland. The 19, 20-year-old who has got a taste for it, sadly, and he got a taste for it after he was pushed into it when he was 15 or 16. Now, it doesn't have to be restricted to expert evidence. The judge may raise an eyebrow, but it is admissible evidence. It is evidence beyond which certainly a jury can rely on from their own experience. But you might be able to get information from schools, from people from educational establishments that he's been in, his former carers, other background evidence which shows an itinerant lifestyle and a susceptibility to being basically taken advantage of. All those factors could knock it down, a 23-year-old, what appears to be a defendant who's got the taste for it, to somebody who's straddling significant role and lesser role, because as Edward said, if you have been engaged by those factors, it's relevant, isn't it?
It's explicitly provided for in the guidelines, and the other consequence of that, as you approach to sentencing exercise is that rather than the old slightly mathematical formulaic exercise of which box does it fit in and how far along that box does the case travel, there's room in this for the kind of mitigation that was, I think, once thought to be a bit old-fashioned, which is to look back into the youth, back into their childhood, and really paint the life story of the defendant in the dock and try and bring them to life in a way that engages the guidelines rather than simply negotiating as to whether you're a category 2.5 or a category 3.
Do you mean the artist formerly known as personal mitigation?
Imagine bringing that back. Yes.
Well, it's funny you say that, because in the authority of White and CPS, they copped out slightly of the saying that, well, you know, this is classic lesser role, because they used a multiplicity of factors to get the sentence down from 3 years to 18 months, which is low. It is low for somebody who's going out dealing drugs, Class A drugs, on 4 or 5 occasions to an undercover police officer on a guilty plea, albeit at the earliest stage, because you're getting it under full discount, aren't you, for lesser role category 3. And they referred to an abundance of personal mitigation. So what this does is it's not double counting. Just because you're in lesser role category 3, and we stick to that because it's something that most people are familiar with, as understand it, have dealt with in a drugs case. Is 4.5 years starting point for significant role category 3 and 3 for lesser. So you're looking at how far can I get below 3 years? Let's be honest about it. That's if you've got a young boy with a chance, a young girl who's got a chance of turning their life around, to use the cliche. How much can I go? Even if they've been caught red-handed dealing on the streets. Well, my view is that the expansion of lesser role, especially with additional material, will allow you to do a White and CPS and go below 2. And that's suspension territory, as we all know.
The guidelines then provide for potential suspended sentences in those kinds of cases which previously they probably wouldn't have been available for. But there's another adjustment called for by the guidelines and explicitly recognised in terms of the need. The Sentencing Council, as part of its consultation for drafting these guidelines, conducted a very significant data gathering exercise as to the sentencing outcomes for people from various identified protected groups, and therefore collected the guideline or collected the sentencing data for women as opposed to men, and for people from Black and minority ethnic backgrounds, and specifically Asian backgrounds, as well as a separate category, and compared them all to each other, and found that men were more likely to get immediate custodial sentences than women in comparable cases, and that in broadly comparable cases, white offenders were more likely to be offered the chance of suspended sentences, and within the sentencing of immediate imprisonment that was imposed, Asian offenders on average got longer custodial sentences than anybody else. So, having identified those specific mathematical trends, the guidelines now direct judges to have regard to that, don't they?
They do, and regardless of people's personal perspectives, most practitioners would consider that a welcome change, particularly if you are regularly have represented people on the margins who haven't had a chance to. And Edward and I have discussed this before, and what Ed said was, look, if you've got somebody in that category, I think it's what he said, isn't it, Ed? If you've got that someone in category and you are looking at sort of 2.5 years, and you've got a real chance, if you then apply the imposition of custodial sentences guideline and look at factors for suspension, well, run with it, especially if use a personal mitigation and say that this is not a typical case. This is a person from this background. We could just do the write-off, give him 2.5 years, 3 years, yeah, borderline significant role, lesser role. But is this somebody who was drawn into this, was immature, was schooled into this regrettable way of life, and he, in the last 6 months, is trying to do something. Do you mind if we just deal with a question?
I see
Because
this question.
There's a question from Ben Waters, who most of us know. Do you think that these guidelines are going to increase the number of trial of issues dealing specifically with the factors contained within significant lesser role? For example, the judge requiring to hear or read evidence that someone is dealing to fund their own habit? I think that's a very good question. And it comes on to something I was going to say about how using our judgment and not asking for an NRM referral for Don Vito Corleone. You know, we've got to be a little bit responsible about the using our judgment, and also avoiding the dreadful Newton hearing from a defence perspective, and assisting the judge, because he's going to potentially, he or she is going to be bored of other good mitigation that you have amassed. But if you've got, it's really about thinking about this issue earlier on, isn't it? Rather than going, you know, writing a, well, we've all been guilty of it, hands up here as well, a slightly ambitious basis of plea, based entirely on unchallenged or unexplored instructions. The defendant has been a hopeless drug addict since, you know, and he did this to fund his own habit. And you turn around, and the only drugs your defendant's probably been addicted to is anabolic steroids. And you think, well, it doesn't really wash, does it? But if you've got a situation where there's evidence to back it up, and some evidence of the defendant being in a rehabilitation centre or seeking, or a prescription being reduced, that's powerful evidence, isn't it, of fitting into the realistic cog of your basic plea on instructions. But in a nutshell, I'd agree that with Ben's question, I think that the issue of Newton hearing is going to be considered more often, especially if a defendant is running into, it is not uncommon for a defendant to say, oh, well, I'm lesser role. You obviously know more about the law than I do. So they'll tell you that lesser role. Yeah, so, well, what were you doing with that 3 kilograms of cocaine and the £20,000 of cash in your sock? Oh, I don't know, but as long as it's lesser role, I don't care, Mr. Siva. Fine. So degree of realism, but also be alive to the fact that a judge may want to hear. The prosecution may not accept that assertion. I don't know if that partially answers the question. It's just a thought.
I think it does. I think another point to draw out of this, of course, is that a Newton hearing will be ordered where there's a tension between the basis, the factual basis of the offending.
Yeah.
Often when you're trying to advance this kind of mitigation, it won't really stray into the nature of the offending, the facts of the offending. It'll be the motivation for the engagement of, and that, as you've said earlier, will be a matter of gathering evidence, completely separate to how the offence was committed and where the offence was committed, but about how that person became involved in the first place. And so you won't be challenging the prosecution evidence. You won't be advancing a contrary factual matrix. You'll simply be looking to put additional evidence in front of the court to nuance the picture, and to say that while this is an example of dealing of this amount in this circumstance, because of the background of this particular offender, actually the guidelines allow for a softer approach to be taken due to historical circumstances.
Or at least a flexibility in movement and going to the cusp. And you might be able to make a submission that, notwithstanding some difficulties on the basis of plea, that a Newton hearing is not required if your big ball point is not challenged. Was an addict in this refuge or this rehabilitation centre a year ago, and that's unchallenged, and that's the platform from which we advance this strong personal mitigation. And you may wish to either speak to a client about the wisdom of pursuing the still addicted point, if that's a position. But the other thing is, if those matters are within the defendant's personal knowledge, there are some minor exemptions to Newton, but they'll still likely to, the judge is likely to want to hear submissions, at the very least, on the authorities. But if your client sounds convincing on that point, he may not lose much credit. He may not lose much credit, Ed. What do you think? I mean, if he said, look, this is where I've got the evidence here. This is where I went to. This is the prescription that was reduced, and I'm now on 10 mils of methadone a day, and here were my 5 or 6 convictions for shoplifting when I relapsed. So don't be frightened, perhaps, of pushing the issue to certainly indicating that your position will not change. If you have faith, or realistically there's a reasonable framework that shows that your clients are likely to be telling the truth on that issue.
And of course, I always think in these cases, historically, with the guidelines as they have been since 2012, I think there's a general reticence across the profession to have Newton hearings. You don't want to give up that level of control if you can avoid it. They're a risk.
The fear of loss of credit.
The fear of loss of credit is huge, and too many judges take too bold an approach when withholding credit after Newton hearings. But the other aspect of the guidelines that's helpful is where you can focus on submissions, as you say, about the cusps and the overlaps and the gaps in between, and remember that language is expectation of limited financial advantage, including but not limited to.
Great point. Limited but not including. And Ed and I have discussed this, because what that does potentially is that the defendant who got 50 pounds for a courier run, and there always used to be, well, he still plays a significant role. Well, he probably does, but have a look at the overall matrix, the potential advantage in the overall scheme of things, particularly if he was desperate for cash and he was used because he was an obvious port of call. The likelihood is that because there is a reference to limited advantage, and it doesn't have to be a couple of wraps of cocaine or heroin, you could easily qualify as, or you should qualify, in fact, you should qualify as lesser role, shouldn't you? If it's a limited, small fact. What about those 2 other words, insignificant, and we now know how much financial advantage is, don't we? If it's really, really big, what's the word? Really big.
If it's really significant.
I think it's significant if it's significant.
Yes.
But if it's massive, is it a
substantial financial
advantage? So we don't know how much you've got to get in cash for that substantial financial advantage to be leading role. But I imagine it's a lot, isn't it? More than significant? What do you think?
Well, it's substantial more than significant. I think
it depends
decided it is.
Depends how substantially significant it is.
It's a significantly substantial sum.
It's a significant change. But these are these words going around. Somebody will have to decide it, probably in the Court of Appeal, what the significant financial advantage is in significant role and what the substantial financial advantage is for somebody with a leading role. The starting points and the ranges are still the same, aren't they?
They haven't changed, but the opportunities to move around are probably where this guideline's different. And if you're having a Newton hearing, or even if you're just having an argument about how the guidelines apply to a particular case, those ambiguities and the increased qualification of the qualifying criteria for which category you're going to fall into give you far more scope to approach the case avoiding Newton hearings by simply saying, well, here are my submissions as to why there are at least features of a lesser role. So even if it is significant, it moves down. And then you can use the other aspects of the guidelines, the exploitation, the grooming, the equal treatment bench book for racial disparity and gender disparity, and you could use those features to hopefully achieve greater reductions than would previously have been possible from those same starting points.
Well, the headline we had at the beginning of our overall analysis is there should be greater flexibility for judges who sentence, and all these factors point to that hard edge being taken away. There are no hard edges, and the lines do blur. So if you've got, you can use it as a template for mitigation or available mitigating factors. If you've got a series of lesser role factors and perhaps one leading role factor, this is the situation that I find interesting, because on a 5-year starting point, it is 5 years, isn't it, for category 2 lesser role. If a substantial quality, if personal mitigation, as in White and CPS, has been permitted to take the case outside, right to the bottom of the range, and possibly even below it, ensuring that, or having a chance to have somebody who you should really advise you're going to prison, this question of how long, who will try and keep your sentence to 3.5 years or 3 years if you plead guilty. There is a possibility the cumulative lesser role factors, if they apply to your case, may give you a chance of a rehabilitative sentencing order. And a judge, the great thing is you can say, Judge, you're not going to get Attorney General. It says here, look, and you can move around the guidelines. So I think there is flexibility in that way.
I think before we move on to the psychoactive substances and finish off with a quick trot through that, looking at the guidelines on the Misuse of Drugs Act, one final point, where those criteria are met, that you are one of those protected groups, your defendant falls into one of those protected groups who the judge is directed to have regard to the disparity of outcomes, you really can be far more bold in mitigating than you would have been previously, because of those features that we've identified in the guidelines, and because of the obligation, the sentencing guidelines, the Sentencing Council having written the guidelines so as to put an obligation on judges to have regard to the disparity in outcomes. If you really push that 21, 22-year-old, 25-year-old, not so old they're beyond redemption, drug dealer, convicted of supply, possession with intent to supply, and you highlight that the movement within the categories is possible, and that they are from a group who historically have been treated in a different way, the chance of achieving that one in every few cases suspended sentence that you really think is justified is increased significantly, and you really have got to grab that case and advance the mitigation as forcefully as you can.
You have, and my view is, I think from a practical approach, what do you do about it when you want to try and help the judge out, help the court out with a realistic what you're going to advance? What you don't want to do is bung all this material in section P for the judge the night before, because the judge, if he's had a quick look at it, and he'll have a busy list, may not be, he might have a quick look at it at 4 o'clock. But if you upload it all on the morning, and he's had a look, it may be more difficult for the judge to. You might have a harder job in oral submissions to say, look, I know it looks like significant role, but judge, let's have a look at this. Set out a framework, set out a couple of documents, maybe even a 2-page submission or 1-page submission. We rely on these factors and those within the guidelines. And even if there's a discussion on the day of sentence, if you're confident about your position, not telling the judge, look, give him 3 years or give him 7 years. What you're doing is trying to helpfully draw the judge's attention in advance of the sentence hearing, those points which fundamentally may move a defendant to a different category in sentence. So it's worth, again, a bit like the experts report or a bit like an educational report, if you've got worries about their ability to understand things. The fact that immaturity is included in the new guidelines in lesser role, and it wasn't previously. I mean, what do you think about that, Ed?
Well, it gives you an opportunity, not just to work with young offenders and people who have the benefit of the youth guideline and so on, but to obtain evidence, as you say, to support a submission. Someone doesn't act, think, rationalise in the way that someone of their chronological age would be expected to. And again, it's an interesting point where not only can you say my client today is immature, but you can say this is someone who became involved at a time when they were
through immaturity.
Immature. And that's the two potential aspects of those dynamics: exploitation, vulnerability, etc. Vulnerable now or vulnerable then, and since has behaved in that way.
Yeah.
But with an eye on the time, I think we should
smash through some psychedelics.
We should hit the psychedelics at this point in the evening.
What do you think about 3-D-methyl heptile 11 hydroxy hexahydrocannabinol? What do you think about that?
I expected a better pronunciation from someone with a science background, but
well, okay. How about if I call it 4-dimethyl?
Well, that's the point. You're talking about spice.
I am talking about spice.
And the psychoactive substances comes because substances like spice, synthetic cannabinoids, produced becomes an immediate problem, hugely addictive, has an enormous unpredictable effect. And it's cheap and it's easy to move around because it can be soaked in a paper and then smoked. The problem that the government had was you can outlaw that particular chemical formula, and that's how the Misuse of Drugs Act works. The Schedule 2, you can put that formula in there, but then some genius somewhere in a laboratory will just create
16-year-old bright spark with a chemistry set. He's going to be on it.
They're going to create something that's chemically tiny different,
slightly different. So you could add that, make
same
it
effect.
Make it 12 hydroxy. Change a little hydroxy.
Well, I was just thinking it would be 12 hydroxy. Would be the obvious.
12 hydroxy.
That's the tweak I'd go
for. So essentially, it's to try and beat the game, isn't it? But importantly, it doesn't criminalise people simple possession, is it?
No.
So it's for the sellers, the people who sell legal highs and make it widely distributable. If the test is not what the chemical is, because only the original spice, it would appear, has been prohibited into Class B.
Yes.
But the effect, psychoactive. What's all that about?
Well, it's the effect that it has, the change in the state of consciousness, and that creates nuance. And the argument's already been run unsuccessfily. That the reason
Chapman and others.
Chapman, the reason I had all those balloons full of nitrous oxide is because they're a potential medical substance.
Of course. Is that why you were hiding in the toilets of the sixth form disco with your man bag with a 50? Couple of questions. Sorry.
Kannan was just getting into his man bag chat.
Yeah, Chapman basically said, look, case by case
basis. You're not having it for medical reasons. If you're
if it does alter the mind and you're selling it for mind-altering purposes for a retail supply, then.
While Kannan looks at the questions and formulates his answers, and if necessary, Googles the relevant material.
Great question.
I'll just very quickly address one more thing, which is to say that the structure of the guidelines on the Psychoactive Substances Act, the rules are broadly similar to that which you see in the new drugs guidelines, but when you're calculating harm, there are references to the size and scale of the operation, but they have to be read in tandem with what the drug does. And so the court will need to have evidence about what are the effects of the drug and what are the risks of harm and what are the percentage chances of that manifesting itself. And the more serious the potential harm, the more serious the effects, the more seriously the drug will be treated. And that's how, although they're on Class A, Class B, etc., that drug will be sentenced differently depending on the nature of the substance that's being supplied.
And that's why on the psychoactive, the psychoactive part of the question of the drug, what we do is look at the effect, meaning of the psychoactive substance, and its some assistance is provided, is it causes an alteration in the individual's state of consciousness by producing a range of effects, including but not limited to hallucinations, changes in alertness, perception of time and space, mood or empathy with others, and drowsiness. I'm just thinking back to, it's really a flashback from school, some of my friends, and it would be very difficult to see those changes in consciousness, even with the strongest of drugs. But the point is this: the stronger and more potent the harm is, as Ed said, the higher you are going to be, the further up the sentencing range you're going to go, isn't it, Ed? Because obviously you're messing with some serious, even though these are experimental drugs and not classic harm drugs. The potency could still be severe. And I go back to the example of fentanyl, which is now classified Class A drugs, extremely potent. So it's treated seriously.
And the guidelines, just in general terms, without reading them out, if you're in category 3, which is designed for very low level supply, you've got a realistic chance of avoiding custody. If you're in category 2, you're on the cusp. But if you go into category 1, and there's every chance that a drug or a substance which has a sufficient effect will allow a judge to move up to category 1, then you're in real trouble, and the starting point can be 2 or 4 years accordingly. So big differences. Questions?
Can we just deal with this? I think it's a very good question, because the there are a couple of approaches to this. It's not an easy one. Question from an anonymous attendee. Currently, there's often no benefit to advise a drug dealer to give an account in police interview. Do you think the new guidelines would potentially allow more consideration in putting forward an account? For example, where pressure, exploitation, grooming or control seems relevant. It's a very good question for this reason. If you are of the view and assess, I mean, it's difficult because there's limited time, but there is something in this. And the likelihood is that there is the challenge to the facts of being caught with these drugs, being seen dropping them off. You know the telephones are going to come back, it's going to hurt. And the only relevant issue that's going to be considered, two issues. One is, should this defendant have the protection of the national referral mechanism? And in light of a relatively recent case, and I'll get my hand on it because I'm going to get killed for this because my friend was in it and she was leading counsel. It is an authority decided in February this year where forced labour and the prohibition against forced labour was considered, or the prohibition of punishment on forced labour was considered, and the defendant, who shouldn't have been prosecuted, was awarded compensation. It's BC and AN in the UK, but I will be corrected. The point is this: if the issue is, I want to consider whether actually I was compelled to do this, but in any event I was under exploitation, that might be a sort of two things in one defence statement slash basis of plea, couldn't it?
Well, they're two separate issues, especially at the police station stage, which is what's being asked about there, which is interesting because there's no reason why a person can't say, I have been exploited, trafficked, pressured or intimidated without making an express concession as to what the nature of their conduct as a result has been. So obviously it'll be case by case, but you might have the scenario where someone is undeniably caught with a quantity of drugs in their possession. Now, they may not want to admit what they were going to do with that, how long they'd had it, etc., but they may want to say, to the extent that those drugs were found in my possession, they were only there because I've been exploited, intimidated, coerced, etc., by more sophisticated criminals. So it is the kind of thing which, while often with a defendant of that nature, you'd be reticent about allowing them to answer questions anyway, if you are considering a prepared statement, bear in mind that that prepared statement could deal explicitly with the issue of exploitation. And you could indeed, in writing to that prepared statement, I don't know what your thoughts are, but there's nothing to say. And I suggest that my circumstances justify a referral.
Yeah, I would. That's what I was going to say. Because if it's put as a prepared statement, it becomes a basis of plea when it goes to court, doesn't it? It might be as quick as the magistrate's court, but there is authority to say that you shouldn't expedite these decisions unless you know a fuller picture. So if it's put in as a prepared statement in which 2 or 3 lines are set out, it can always be reviewed as to whether that reaches the dizzy heights of a defence. Often it won't, and you have to be realistic. But more often, you will probably the question is probably directed to the situation where it is a basis of plea case, not a defence case, where the test for Section 45 defences, of course, is still very high. This Section 45 in slavery defences, because you're having no alternative, and that's a high test. Whereas if it's somebody who's been engaged, inducted, they're sort of doing it voluntarily. They like some perks, but they've been corrupted beyond belief from the age of 14. They're only 18 now, and they may even be drawing other people into it. If you can make a snapshot of the headline points, what it might do, and it's a judgment call, is if the core points are not shaken in terms of credibility and the basis could be short, or the prepared statement could be short, it might provide a very credible template when you're considering whether or not the court should be litigating this issue or persuade the Crown to say, look, he did set it out. Now, some judges are very impressed with a defendant who sets out the stall. He's had the courage to say what the position is in an interview. The difficulty comes, of course, especially when people are roped into large conspiracies. And how can I put this politely? People are sometimes tempted to minimise their position and have their credibility exploded by 5 or 6 telephone patterns which show they're talking nonsense. So it is a judgment call, but there is benefit in certain circumstances. So benefit in advising a drug dealer. Answer: what sort of drug dealer? However, how strong is the evidence of exploitation and grooming? How good is your assessment? If you set the tone at an early stage, it may assist you in one of 2 routes, including sentence.
There's a question as well there from Emily.
Emily,
given that there are often cases where the only evidence of a defendant acting under pressure or intimidation comes from the defendant himself, and often is affected by fear of repercussions, how would you suggest to a defence advocate we go about evidencing the suggestion to the judge they fall in a lesser role rather than significant? Sometimes that'll involve collecting more historic information to show the time when they were on the right path. So you might want to go back and get even things like school reports and statements from former mentors or people they've worked for to show the positive time in their lives and the positive achievements they have made.
That's right, because ultimately, when a defendant ends up in the Crown Court for drug dealing or drugs offences, the question is, what went wrong? How did they get there? And what this does is give a stronger focus on some of the factors which led to that. But again, I would use judgment rather than simply just, again, compromising the defendant's own position, because it's not unknown for a defendant to simply, what I call, have a reusable, being passed around Horfield defence, and just if there's some material or some, but there's a duty, of course, to investigate that anyway as any advocate, and not write off a background which should lead to a positive referral, for example, protection for that individual, and we're derelict in our duty in not identifying those. But fear of repercussions, that's a more difficult one, because often you're not going to name.
Sometimes you'll be able to derive a bit of evidence to support that from their antecedents themselves, if they're not particularly involved in heavy criminality before.
Yeah.
There's been a trajectory. What's the reason for that trajectory? And do people following that route usually have a certain reason for having done so?
So again, going back to the background building blocks, as you said, Ed, if you've got background evidence of a remarkable fall from grace or a fall from effort, you're going to be able to build that picture more readily, aren't you? Yeah. And ask. I remember doing a Newton hearing quite a long time ago, in which the defendant's basis of plea was, quite frankly, absurd. That he had just borrowed the dealer's list, which was in his back pocket, in his handwriting. It's just. But the unused material schedule, and I inherited the case for the day before the Newton. It was quite clear that there had been reports by the defendant's father of people banging on the door and shouting and demanding stuff, and the boy was only 18, 19. So I call him a boy. He was quite a young, skinny, vulnerable 18, 19, rather than a hardened guy. He got in with the wrong crowd, and we lost to Newton, obviously, on the absurd account. But the judge, quite properly, a recorder, said that the evidence he heard, he was prepared to accede to the submission, that there was evidence of pressure short of duress, and losing the Newton still resulted in a sentence of 18 months imprisonment. So, applying that to these guidelines, you can still build up the picture if it's relevant to the task the judge has to do. I'll note the time, Ed. Are there any other topics that...
I think we've covered what we set out to cover. Are there any other questions about to arrive or ping in? It looks like we've answered a few people with further queries. So I think it might be time to wrap things up to a conclusion.
And thank you for joining us.